Hi everyone, my name is Swayam. I'd like to first start off by recognizing the traditional, ancestral, and unceded territory of the Musqueam, Tsleil-Waututh, and Squamish First Nations on which we are moderating this webinar for you today. Thank you so much for being with us and for being open to learn more about the topic of this webinar, victims of Canadian federal offenders, meeting needs, and improving supports. As I mentioned, my name is Swayam, and I myself am a member of this Citizen Advisory Committee with the Metro Vancouver West Community Corrections. And today I'll be co-moderating with my colleague Eddy, who is the co-chair of the Citizen Advisory Committee. This webinar is of particular interest to me as it brings together my own experience working in public safety. I've spent 3 years working with adult federal offenders on parole. And for the last 2.5 years, currently I've been working with victims of violent crime under the Ministry of Public Safety and Solicitor General. And so I hope our shared interests will stimulate some deep conversations and interesting questions over the next few hours with our guest speakers. At this time, I'll hand over the virtual mic to Dennis, who is the Area Director for the Metro Vancouver West Community Corrections Vancouver Parole Office. And then we'll hear a little bit more from my colleague Eddy about the purpose of our webinar and some of the work that the Citizen Advisory Committee has done. So I'll hand it over to Dennis. Thank you.
To everyone that's joining us here, I think we have participants from every province and territory in Canada, a number of the states in the United States. And we also have a bit of an international audience. I know we have participants, I believe, from the UK, India, Nigeria, Fiji, and the Philippines. At least those are the ones that I picked up from the registration list. So if there's others, I apologize, but we're very excited to have you join us from wherever you're coming to us from, whether it's in Canada or internationally. So again, my name's Dennis Herfst. I work with the Correctional Service of Canada. I oversee the Vancouver Parole District. For those that maybe aren't familiar with CSC, Correctional Service of Canada, we are a federal organization here that is responsible for the administration of sentences of 2 years or more. So people that are sentenced to 2 years or more, we are responsible for the care and custody of these individuals in our federal penitentiaries, and then also supervision on parole in the community. And that's specifically part of my role, the community piece there in Vancouver. We have a local citizen advisory committee of which Swayam and Eddy Elmer are a part of. Our citizen advisory committees are groups of volunteers that are associated with not only our parole office, but almost every penitentiary and parole area in Canada has a local citizen advisory committee that they work with. And these are groups of volunteers that are supposed to be independent and impartial. And their role is to effectively observe, liaise, and advise on matters related to correctional policy and practice within our Correctional Service of Canada. So locally here in Vancouver, we meet together once a month and review various topics and policies that are pertinent to the day here in the Correctional Service. And sometimes we'll go on tours of the institutions. They can meet with our federal offenders that we supervise, attend our local halfway houses, etc. So it's a great collaboration and partnership that we enjoy. And again, this is one of the ways that CSC tries to be transparent in terms of its operations and how we conduct our business. So that's a little piece about who we are in corrections and our local citizen advisory committee. I will turn it over, I guess, to Eddy for a few more words on that and getting launched into our formal part of our presentations today. With that, I'll also add preemptively a thank you to our guest speakers. I'm very excited to hear from them as well today. From Tara and Heidi and Pat and Donna, and particularly Pat and Donna, a special thank you to you for being willing to share your stories with all of us today. Hearing from victims is extremely important, and obviously we'll hear more about that over the next couple hours and what's working, what's not, perhaps, in terms of the way you are a part of the criminal justice system, but a special thank you to each of you for being willing to participate with us here today. So Eddy, I'll turn it over to you.
Thank you, Dennis, for the introduction, and thank you to all the people who've signed up. My name's Eddy Elmer, and I'm the Vice Chair of the Citizen Advisory Committee for Metro Vancouver West Community Corrections, and I've been on the CAC since 2019. We've been involved in many activities over the last few terms. As Dennis mentioned, we have visited penitentiaries and community-based residential facilities. We've also hosted a number of very interesting speakers, and most recently we had the Right Honorable Jody Wilson-Raybould, our former Minister of Justice, attend the Vancouver Parole Office and have a conversation with us about Indigenous offenders, and that was very eye-opening, very interesting. We hope to have more speakers as we come out of the pandemic. Lately, we've also taken a strong interest in aging offenders, which was highlighted in a webinar we did last year around this time, and I'm sure many of you attended that. It was very well attended. Most of our work so far has focused on the needs of offenders, but we recognize it's equally important to focus on the needs of victims as well. They must manage not only the physical and mental toll that a crime can take on them, but they also have to navigate a system which can be quite daunting and confusing for them. And trying to figure out what services are available to them and how they can register to find information about victim, information to which they are entitled. So we hope that this webinar will provide some information to help victims and service providers understand this web of services, and also to identify some gaps and barriers and challenges that victims have had in accessing the service. So we hope you enjoy this. Please feel free to ask questions in the Q&A window, and should that not work, you can ask questions in the chat window as well. So I'll turn it back to Swayam for some other housekeeping issues.
Thank you, Dennis and Eddy. Yeah, so just before we introduce our amazing guest speakers today, I'll go over a couple of housekeeping things with you all. So each speaker will have about 20 minutes to share their stories, after which we'll have about 30 minutes for Q&A. If we do go over time, the speakers agree, we may be able to answer a few more questions in that overtime portion. Please do use the Q&A window to ask your questions. That way we can monitor that a little bit more easily than going through the chat, and make sure we get your questions to our guest speakers. And if we're not able to get to your questions in the Q&A, please do feel free to type them in the chat. We'll try our best to bounce back and forth. You can also use the chat to network, so feel free to connect with your peers here. We do ask for everyone to be respectful of their comments throughout the discussion today. For those who cannot stay for the entire event, we are recording the session and it will be posted in about a week for later viewing. It'll be posted on YouTube, and I believe we will be sending out a link to everyone who has registered for today's session. If you do happen to get cut off at any point during our webinar today, please do take a few minutes to give your computer a break and then try logging back in, and hopefully we can get reconnected at that point. We recognize that the content of today's webinar can be quite heavy and may be triggering for some. So we do have a list of resources here to share in case you do require any immediate support during the time with us here. Just trying to navigate my computer so I could share that information with you. Just give me 1 sec here. I'm having some of my own technical difficulties this morning. So hopefully everyone can share my screen here. If I hit the slideshow mode, it's going to take me out of the webinar, so I'll just leave it as it is. But we have a resource to Crisis Services Canada, the Canadian Victim Services Directory, Hope for Wellness, Kids Help Phone, and Victim Link BC. And we will be reposting this information at the end of our conversation today. So for any of those who do require immediate support following our discussion. Did I get everything there, Eddie? Was that all for housekeeping?
I believe so, yes.
Okay.
So I will just briefly introduce our speakers now. Normally I print everything, but my printer died, so I have to go by my handwriting, which is, bear with me because I can't read my handwriting. So we'll start with Tara George. Tara is Manager of Victim Services for Correctional Service Canada Pacific Region. She oversees coordination of services between CSC and its partner agencies. In addition to working in victim services, Tara has worked in community parole supervision, sex offender relapse prevention, restorative justice, incident investigations, temporary detention, and interregional transfers. She's been with CSC for 24 years and has been in her current position since its creation in 2007. Tara has a BA in criminology from Simon Fraser University and an MA in criminology, in European criminology, from Katholieke Universiteit Leuven in Belgium. I hope I pronounced that correctly. Pat Henman is a victim advocate from Nelson, BC. In 2013, Pat and her daughter were struck by a drunk driver, which left both of them with life-altering injuries. Pat is an artist and the author of the book Beyond the Legal Limit, Surviving a Collision with a Drunk Driver. She's also a volunteer of MAD Canada, just Mothers Against Drunk Driving, and a member of the Pacific Regional Victims Advisory Committee. Our third speaker is Donna Eaton, a victim advocate from Calgary, Alberta. In the year 2000, Donna's 20-year-old daughter, Brooke Clapson, was murdered by Brooke's ex-partner. Since then, Donna has been advocating for the needs of victims of domestic violence and offering advice on navigating victim services. I had the privilege of meeting Donna through Nancy Hickst, who is a crime reporter with Global BC, with Global News in Alberta. And I thank Nancy very much for bringing us together. And finally, we have Heidi Illingworth, a former federal ombudsman, I think should be ombudsperson, for victims of crime, and the new executive director of Ottawa Victim Services. Prior to these roles, Ms. Illingworth spent 20 years providing services for victims of serious crime and interpersonal violence. She served as the executive director of the Canadian Resource Centre for Victims of Crime for over 11 years, and also developed and taught courses in the post-secondary victimology program at Algonquin College in Ontario. Ms. Illingworth has been a strong advocate for strengthening the Canadian Victims Bill of Rights, and she will speak about that during her presentation. So with that, we will turn to our first speaker, Ms. Tara George.
Tara, I think you're on mute.
Okay, I've got it. I was thinking, everyone, I think I had it, but I guess I didn't. Okay.
You're all good now.
Now we have it. Can you see the PowerPoint presentation? Hopefully.
Yes, we can.
Okay, thank you. Thank you very much, Swayam. I want to thank everyone from the Metro Vancouver Parole Office, Dennis, and the Citizen Advisory Committee through Eddy and Swayam for inviting me to speak today on victim issues. It's something that is of great importance to us and the work that we do in corrections. And so thank you for creating this opportunity, and to all my panelists who I'm here with today, thank you. I also would like to acknowledge that I'm speaking to you from the unceded territory of the Coast Salish peoples, including the territories of Matsqui, Sumac, and the Lekwelem nations today. And finally, I'd like to just share with everyone that I am one of 5 regional managers across the Correctional Service of Canada. We're a small but mighty program. We also have a small office at national headquarters that provides us our guidance and support for the National Victim Service Program. And so today, my goal and role with everyone who's joined us from across the country and even internationally is to provide a very high level overview of some of those features and leave you with the important pieces around our work of trying to engage with our partners and stakeholders and clients to raise awareness about the needs of victims, hear from victims and incorporate that into the National Victim Service Program and our service delivery on an ongoing basis, and to share what we do and learn from our other victim serving agencies about what they're doing in community to try and meet those needs. So I will be using examples from British Columbia throughout the presentation. That is my experience, but I just want to ensure for everyone that we are reaching out across the country, and for every municipal and provincial and territorial agency, victim serving agency over the years, we are continuing to, if not already have built a relationship with you, exploring opportunities to do that so we can become even more of a critical piece in raising awareness and knowing the information and working together to try and bridge gaps and streamline duplication. So thanks for everyone today for having me speak. With that, I'll, oh, I've lost my ability to turn the, okay, here we go. Just to start us off, the Canadian Victims Bill of Rights, when it came into effect, it gave us a common definition of what a victim of crime in the legal system, what does that mean? And so all of our various provincial and territorial and federal systems laws have had definitions in it and still do that may vary, but we do now have this common definition that we try and ensure when we're working with people. So I wanted to share that with you. In CSC, through the Corrections and Conditional Release Act, we also have some guidance around who we could consider victims of crime and who would be able to provide service. It also, in our legislation, it requires for victims to request the information that we can provide to them about the offender who harmed them or their family members or friends. And so it's it guides all that we do in our area around working with people to try and obtain services and get information. Just to let you know that as of March 31st, 2020, the Correctional Service of Canada had over 8,700 victims who had said that they wanted to receive information from corrections about the offender who harmed them. It was approximately for every, there's about 20% of offenders who we have in our care who have at least one person, one victim who wants information on an ongoing basis about what's happening. And so it's our role to try and meet that as we move forward. The Canadian Bill of Rights brought in the rights to victims about getting information from the legal system. And so we're committed to that. We've always had responsibilities and services through our legislation that I talked about to provide service, but the rights guide us now in a very direct way around that. And we share with victims their rights to information, to protection, to participate in decision-making, the right to restitution and referrals for them in their local and areas to try and access that, as well as redress. So if their rights have been infringed upon and through our service and others, but I'll talk specifically to CSC, then we provide them with information about how to formally make a complaint about that their rights have been violated. So we work through those pieces to try and ensure that the work that we're doing adheres to that and that we can share that with victims as we move along with them in their journey. I wanted to talk a bit about the Correctional Service of Canada Victim Service Program. We are committed to bridging gaps between the different parts of the criminal justice system or legal system that we have in a way from a place of understanding around trauma and the impacts that and what brings victims to be wanting the services that we have. I can say when we started in 2007, the reason that we have victim services in CSC is because victims themselves asked us to have victim services. They wanted their own dedicated staff within the Correctional Service of Canada to provide them their legal entitlements that were under the law that they could access, to provide them with the information, to respond to their requests. And so they wanted workers who were trauma informed and had an understanding of what they were looking for and what they needed, and could share the information that they were legally entitled to in that context. When CSC created the National Victim Service Program, there was an acknowledgement that there were existing victim services all throughout Canada, in local communities, through provincial services. And so the goal was not to duplicate any services that were existing, but to fill a gap that was acknowledged around the care and custody of offenders in federal jurisdiction, and to try to make sense of that to victims who are going through those processes and want to access them and understand them in a more meaningful way. And so our role and goal has always been in the National Victim Service Program to raise awareness in our own program about what is already available in local, municipal, provincial, territorial sectors, to understand and refer back to those programs who provide the crisis care, the emotional support, the counseling, financial assistance, all of those meaningful things that have been in existence and continue to do so. So that was the first part for us to understand that, but also then to meaningfully engage with our colleagues in the victim serving community so that they understood what the Correctional Service of Canada and the victim services that are available to victims in these times. Being a part of the bigger legal system, people are fairly familiar with police, courts, but when it comes to sentencing and what happens after the sentence, that can be a bit of a struggle. So those offenders who have federal sentences or are granted some form of parole at some point by the Parole Board of Canada, a federal body, then we would be able to provide information. And for those that have a sentence provincially, well, they're mere, how does that work? So we're still continuing to learn and to grow, and our commitment, we've renewed our commitment or maintain our commitment to doing that in a meaningful way all across the country. So like I said, we have 5 victim service units in 5 regions that we have: Pacific, Prairies, Ontario, Quebec, and the Atlantic regions. And so it covers off, in Pacific region, we work with the British Columbia and the Yukon. The Prairie regions works with a number of provinces and territories in their area, and so forth and so on. Each and every one of our units, we follow our protocols and policies set and in agreement with the legislation, but also our national program. So we're trying to deliver services that are standardized so that victims across the country know and can expect standardized service from each of us. We provide and work with victims who want the information from corrections and the parole board, and I'll speak to that a little bit, our work with them. So victims request that information from us, and so we will work with them to try and get their preferences related to that, to inform them about what they can and cannot have from under the legislation and how does that work, bring meaning to explaining those pieces. We talk about, for the most part, a large majority of our work is in sharing information about where the offender is located, whether that's while they're incarcerated or in the community, and the importance of that around for victims to build on their victim safety plans based on where the offender actually is. We also, with the Victims' Bill of Rights, the legislation changed to include additional pieces for victims to receive, including the correctional plan summary of what the offender has been working on in terms of programs and treatment, as well as providing photos upon release, if that's something that they have a need for, and working on just general information about corrections and how does it work. What's the day in the life of an offender incarcerated or on parole? How do parole officers manage that? What does it mean for escorted temporary absences and correctional officers, and going out, why and how's that managed? So we do those pieces directly with people who have asked for it. Key piece to that is victims. Our victim service officers work to try and identify with victims what it is they want, because not everybody wants everything, or maybe they're change over time. So we try and check in with them on a regular basis, or when they share with us their preferences or understand, you know, I don't want this, but I definitely want that. Then we work with them and try and adjust the information we're providing them with what it is that they would like to receive. Another component that we do is, in addition to that right to information, is the right to participation and ultimately protection. So victims who want to provide information to decision makers and to parole officers and case managers who are making recommendations to decision makers, they have the ability to share, to submit statements for scheduled reviews that are coming up, whether it be for a temporary absence being granted by the Correctional Service of Canada or by the Parole Board, because the Parole Board does do the lion's share of our decision making, but there are key things that Correctional Service of Canada staff make decisions on. So we work with victims around that to advise them about those processes, advise them that a decision is pending, that they can participate, that they can submit statements, making sure they understand the limits of confidentiality, so that because a decision is being made about an offender, it will be shared with the offender as that goes through. So we try and work with them around how to do that, and possibly referrals back to work through some of those pieces. We also advise them about restorative opportunities. That was something in the legislation that made sure that we did. We've done that for a long time. There are restorative opportunities within the Correctional Service of Canada. We contract with mediators in the communities in each of the regions to provide that level of service. And victim services, we would raise awareness to victims about that opportunity, and if they would like to have a referral, share with them the mediators information so that they can pursue that. And if that's something that they're interested in. As well as then we provide and kind of are the window into corrections about any of those questions about what we do. And finally, then we share with victims our knowledge and understanding as we've grown with their local, provincial, and other federal services for victims that to meet those needs that CSC doesn't in our program provide, but that in their local communities, how would that work? And so we work to try and ensure that where needs are identified that aren't, to work with victims to refer back into community to the services that are available to them. One of the things why we came to this is we have regional victims advisory councils in each of the regions. In British Columbia, we're marking the 25th year of victims sharing information with the Correctional Service Canada and the Parole Board of Canada about their needs in our work. In the Pacific Region Victims Advisory Council, we've expanded to include partners with Police Victim Services Association of British Columbia and the BC Victim Services and Crime Prevention's branch within the ministry. And I'm going to leave that piece a bit because I sometimes forget how all of the piece. I'll put it up on the next slide. So they partner with us at the recommendation of victims who've been on our committee over the years, because we're trying to address gaps and duplications and address victims' needs from their perspective. And so what we found over the years is that some of the pieces were related to the services that either the Correctional Service of Canada or the Parole Board, but some of those pieces might relate to the services that they're getting in their local community or provincially. And so we now have an expanded council that includes some of those other agencies so that we can look to try and address victims' needs from a wider base. We work together on our communication and presentation plans. You'll see later on some of the slides is we work with our chair and our VAC members to create our presentations, to what types of information to go into them, our joint training endeavors, outreach sessions like today, streamlining processes and practices, and problem solving. So it's key to us, and each of the regions has a similar board that looks through and meets on a regular basis to try and address those needs. And it's important to say that victims of crime sit on that, and that's one of the key components, is that they're telling us what their needs are and how that works, because sometimes what we're providing and what their needs are may be different. And so how does that work, and how can we work together to try and see what's out there and available, or where we may need to refer back on to other legislative or policy-driven discussions at the national level or in your local community. So we work together to do that. This is a slide that came from our Victims Advisory Council, and it's just simply about British Columbia. This is an example. But Victim Services was a grassroots approach to providing needs that victims weren't necessarily getting through the legal system pieces. And so you can see from our slide, here's the Correctional Service of Canada and Restorative Opportunities. Here's the Parole Board of Canada Communications Department that we work with very closely around meeting the needs of federal victims under the Corrections and Conditional Release Act. Police Victim Services in British Columbia, who is a partner with us. We have community-based victim services that provide services. And then we have the ministry, here we go, the BC Ministry of Public Safety and Solicitor General, who provides a number of services, and this is in the bigger bluer column. They have a number of programs and support pieces. The one that we pay particular attention to and work quite closely with is in British Columbia. They have a victim safety unit that provide notifications to victims who are moving through from arrest to provincial care and custody and release. And so they have, and their work mirrors our work in federal corrections in providing notifications to victims. So we work quite closely with our safety unit, because of course they're working with people up until an offender is sentenced to federal time, in which case then that work, does a victim want to continue to receive information with when they move into the Correctional Service of Canada's care. And so we've developed some pieces to shore up, to make sure that victims are aware of that. One of the key things is in the registration form for BC Victim Safety Unit, when a victim is saying, yes, I would like this information, there's a key component that says, if the offender is ever sentenced to federal time and transfers to federal services, would you like to have your request forwarded? And so victims get to right then and there say, yes, I would like that. And so from there, we would get that information and start to work with the victim directly around, or victims around, what kind of services and how does that work when it goes federally. And at times, because offenders return back into community for the most part, or at later dates, then we would work sometimes to ensure that they go back into those provincial services as needed, or if we're sharing jurisdiction from time to time, where offenders may be moving from provincial to federal custody for court or other reasons. And so we would work quite closely with them to make sure that the gaps are bridged to, so people understand where an offender may be, either in provincial or federal custody. Each province and territory will be a bit different. We also in our region work with the Yukon, so there is a different slide there or makeup. I'm not going to review that one today, but it gives you that sense of examples of how we're trying to engage and understand in more meaningful ways, and of course then share that learning with the victims that we work with, and anyone for that matter. So in British Columbia, we have the Victim Safety Unit. So they start at that level. So police victim services who would engage at the onset through the arrest, and or community-based victim services, depending on the nature of the crime in British Columbia. They would be providing the frontline services, but they would also and can have the ability to refer to the Victim Safety Unit to get the necessary pieces around where is the offender, how is that working, what are the court dates if they don't have it. And so from there, they have a after-hours service, so they would be providing those services to victims as they've requested. They have a website. I want to share it with you. There, I talked about their form. And each from the Victim Service Directory nationally that we shared, there will be these pieces, but to coordinate and try and give you an idea of what's happening for us is a victim can go on their website, apply to say, I would like this information. They'll start receiving it. And then at the point that they become federal, they'll come to us. So here we are as a CSC Victim Services Unit in the Pacific region. People can contact us by mail, email, electronic portal. I'll talk about that at the end. It's an exciting piece that for those that are tech savvy can access, and we encourage. We also have an after hours monitoring center to provide information in the after hours. And so that's us. Our website, I wanted to just highlight for our website, it gives you general information about what we do. It also has some key resources. You can get a virtual tour of a federal penitentiary. You can look at infographics about if you're interested, or if a victim doesn't want to get the information directly from us as a service, they can designate a representative to receive that information. It could be a friend, it could be a local victim service worker who they trust and have an ongoing relationship with because they've worked with much longer than for us. And so they say, you know what, I don't want to hear from you directly, but please share it with this person. So we will facilitate that. We also have our complaint process, how to access or submit statements. All of those pieces are on there to access and get more information. And as victim service officers, what we're trying to do is to bring meaning to this. And also from the Correctional Service of Canada's perspective, what does it mean to be incarcerated in a maximum security jail? How does a parole officer supervise somebody on conditional release or statutory release? How do they manage their risk in the community? How does that work? So we're working to try and provide that general information to them. So we have our website there. We also work quite closely with the Parole Board, the Parole Board of Canada, who makes decisions on offenders in federal custody and actually grants in British Columbia, only in some provinces, but BC is one of them, where they grant provincial offenders parole. So once they do that, they would come into federal custody if they're actually granted it. A federal parole officer would supervise that release. So we work with them around, with victims around advising and sharing information with the parole board for them to participate and attend parole board hearings, virtually or in person. With COVID, that obviously has changed a little bit, but their virtual presence has, after I think it was about 3 weeks, they've been able to provide that service to allow victims to participate virtually, read their statements if they so choose, and get information. So there is a communications department at the parole board that provides that service to victims, and we work, victim service officers work with the parole board to make sure that the information during those times when the parole board's making decisions, that they're getting that information and as they would like. The parole board also provides a service to get decisions so that you can request to have a copy of the decision, that any decision that they make. And so that's part of those pieces that we communicate, and we'll connect with our regional communication officers there and any victims that we work with to make sure that they're getting that service as well. There are some, there were some duplications there, so we're trying to work together to try and with our advisory council to say, okay, well, here's the information that victim service officers provide and how, and the role of parole officers in case management in gathering information and making recommendations to the parole board. So at CSC, we work with victims on that, piece, and then the parole board's going to work with the victims around, and this is the decision making of the parole board and how this works. So it can be quite confusing for all of us, and so that's that piece to work very closely together to try and meet the needs of victims as they try to discern, do I want to attend a hearing? Do I want to submit a statement? Do I want to read it? Do I want to have transcripts? How is this going to work? Finances, like how would I, if I want to attend in person, how would that work? So there's some very meaningful conversations to have, and to have that with the parole board staff to do it, and for us to kind of make sure that we can make connection. And finally, we have our victim portal. So we share this with the parole board staff. It's a piece for victims who want this information. They can go online and register to request it. So if they haven't got it through or they're concerned that they haven't got it through earlier referrals from provincial or local victim services to federal victim services, or CSC or PBC, victims can log on and register through our portal. PBC staff and CSC staff work together to manage and maintain this portal so that we can know that victims have requested the information, what types of information they would like, and actually share information back out. So what happens is we would be able to we would post information that we would in the past and still do if people like in the mail or by telephone. We would also be able to post it to an electronic account. They would get a notification of an email saying you've got mail, and then they could log on through similar to processes if you're familiar with doing your taxes online or banking online. It'd be a similar process to that, very familiar. They could log on and look at their account and the information we've shared with them electronically 24/7. They could see what it is. The information getting to people about what they've asked for is the first part, whether it's through mail or electronically, and then we as victim services staff would be there to answer any questions. The law is complex. When we start talking about eligibility dates to even apply for parole or it's legislated, there's a lot of math and law involved in that. We have sentence management officers in corrections that actually do that work. So when we're talking with people, we'll go and we'll say, okay, well, this is how we understand it generally. If there's specific questions a victim may have, we'll liaise with our sentence manager or our parole officer or whoever it is that we're working with to try and get a better understanding of, in general, how does that work, and to bring meaning to that. But definitely in terms for people to reach out to us, and if they have a need and want to have this information, they can do it electronically, by telephone, or by mail. And so that just gives you just a very high level of, from a Correctional Service of Canada Victim Services perspective, how we're trying to raise awareness and work with the victims who want it and our partners who are delivering it. And just a contact for us, here's our email, our general email accounts for all our different offices. I've put our website up there so you can take a look at and look through our website and some of those materials I shared, and our toll-free line. Give us a call.
Thank you so much for that, Tara. I did notice that there were several questions for you in the Q&A window, so maybe you can take a look, and then when we get to the Q&A, you can address those questions. Turn it over to Swayam now.
Thanks so much for that high-level overview, Tara. That was very informative and hopefully gives a clearer picture on how victim service works with the Correctional Service of Canada and Parole Board of Canada. I'll turn it over to our next guest speaker, who is Pat Henman. So Pat, if you're ready to join us, you're unmuted and your video's on. I can see that. Great. All right, thanks so much, Pat. Whenever you're ready.
Thank you. Thank you so much. Can you hear me?
Yes, I can.
Great. Hi, everyone. I just want to thank the organizers for this webinar. I'm really honored to be presenting to you all today. As previously said, my name is Pat Henman. I live in Nelson, British Columbia, on the unceded and traditional territory of the Sinaiaks, the Ktunaxa, and the Syilx people. So today I want to tell you my story, and I also want to tell you what our experiences were after our offender spent time in the federal prison in Fraser Valley. So Eddy had just mentioned that my daughter and I, Maya Vesna, who was 19 at the time, we were hit by a drunk driver. It was a sunny Sunday afternoon, June 9th, 2013. We were just coming home from a really fun weekend in Calgary, visiting my sister and her children. And we got halfway home to a small little village. You can almost blink your eye and you'd miss him, but it's called Skookumchuck. And there's a Kootenay River that flows through there. And just as we got to the other side of the river, Maya, who was driving, noticed that a vehicle was crossing the yellow line. And I don't remember any of that, but Maya does. There were no cars in front or in back of us. There was no one on the other side of this road either. I'm not absolutely sure how long we had to wait, but finally a car came up behind us and everything started from there. The woman driving the vehicle that hit us, she was 32, a mother of a 2-year-old boy. It was about 5:30 in the afternoon on a Sunday, and she had been drinking all afternoon with her friends in 2 pubs. Then when she realized that she was supposed to go pick up her son, because it was her week to have him, and she was going to go to her ex's house and pick him up. She didn't have a vehicle, nor did she have a license, because she was already on suspension for hitting a logging truck while she was drunk 11 months previously. So she stole her friend's SUV and she drove 17 kilometers before she drove head on into our Toyota Corolla, changing our lives forever. I don't remember that day. And then I don't remember anything for approximately 10 to 11 days. I was in a coma for 9 days. I had 19 surgeries over those 9 days. I was revived 4 times over that period, once at the scene. My daughter Maya, who was just finished her first year of university in Calgary at that time, she broke all 4 limbs. We had so many injuries, it would take quite a while to go into it, but needless to say, it took a very long time to recover physically. And actually, we still aren't. And of course, there's the PTSD, et cetera, on top of that. So that's the beginning of the story. Of course, being in the hospital is a whole other part of it. I spent 6.5 months in 4 hospitals, both in Alberta and British Columbia. Now, while we were in the hospital and still recovering, things started on the legal side at the very same time. The civil suit started almost the day of the actual crime. We had lawyers ready to take our case the very next day. Part of my story is that the actual Crown in our case, it was at least 11.5 months before we even knew that they were going to continue and take this case on. As I said before, the offender was already on a suspended sentence for her license, but that was her 3rd DUI charge. She was a serial drunk driver, and I was scared, very scared and concerned that her 4th time was not being considered a very serious issue. And I didn't know if the Crown was ever going to, contact us. So I contacted them. I phoned them 11 months after. I had been home for about 4 months at that point from the hospital, and I was using a walker, and I was not eating yet. I was on something called TPN because of all the internal injuries. But I was incensed to get this thing going and making sure that justice happened. So I called the Crown in Cranbrook, and they said they hadn't looked at it yet at all. And here it was 11 months. I called my MLA, my MP. They said they had no jurisdiction over that type of issue with the Crown. But within 2 weeks of all that, I did receive a letter saying that they were going to start proceedings. So in November, which was 15 months after the crime, the first hearing happened, and we went on from there. The first day that we were at court, it's a blur to me, but at the end of the day, we were coming out of the courtroom, and the offender was also on the courtroom stairs outside, and she walked up to me and she started talking to me. I swear, it's so surreal, even today, 8 years later. And she said, "Can I give you a letter?" And my family behind me were just like, what is this? I said, "Yes." And she gave me a 4-page letter that she had handwritten to Maya and I. She had all her friends around her, and she was looking at them and, is this good? And so I took the letter and I read it, and it was an apology letter. And then I didn't see her again until Christmas Eve. And that's when the sentencing happened. It was Christmas Eve of 2014. She was sentenced to 2.5 years in the federal institution for women, Fraser Valley. I felt that the lack of acknowledgement and the empathy for the victims in the courtroom was quite palpable, at least to me. It was as if I wasn't there. Maya did not attend. Maya was trying to get her life back in Calgary. She was back in school taking 1 class. She was in a wheelchair. She was going to so much therapy, counseling, physio, you name it, everything, surgeries on a left ankle that has never actually recovered from that crash. But she really could not even get her head around coming to court or dealing with it at all. So my husband and I, Larry and I, and our other daughter, Zoe, we attended the court. But I just felt as the victims, the attention just seemed to be all on the accused. And I think that was talked about a little earlier, how Tara was saying, it used to be focused so much on the accused. But we as victims, we need to be acknowledged in some way. Yeah, the accused in mine did not deny her charges. I mean, she never said she didn't do it. She did give excuses of why she did it, but she never denied it. But I, as the victim in the room, I felt that perhaps we could be acknowledged also. When the judge asked, he said, "We're going to do the sentencing on Christmas Eve," he actually turned to the accused and said, "Now, does that day work for you?" And didn't ask us. And maybe, I never talked to the judge, so I don't know what that means. And someone else can explain it to me why they're asked. But if the accused, if the victim is in the room, I don't know. I don't know what I would have said if they had asked me, but I felt like we were not there, except when we gave our victim impact statement. So that's important for everyone to know. I think we need some acknowledgement. I felt unimportant, I felt belittled, and I felt invisible. For 3 years, my young daughter, my husband, and I spent the majority of our days thinking about, worrying about, trying to understand the situation we had found ourselves in. I just want to say that even though I'm going to try to give it a little bit in chronological order of what happened, all of these things were happening at the same time. Everything we went through happened in 3 years. The crash, the recovery, all of the different therapies we had to go to, the court, the civil suit. Yeah, everything was happening at the same time. Her going to prison, me signing up for restorative justice and also registering to get notices about our accused. Everything was happening at the very same time. So our offender, as I said, was given 2.5 years in Fraser Valley Institution for Women. I said she had 3 previous DUIs. The institute she was placed in was far away from my home, which is Nelson. And I was glad of that. So I immediately signed up for all the updates. I was told I would receive letters in the mail telling me if and when she would be up for parole, if she was released on the day parole or into a halfway house. I wanted to know these things. I was quite worried that she would be back on the road or might even come to Nelson, because I knew that she knew people in our community. I lived in fear of seeing her again or even meeting her on the street. Within 6 months of her sentence, she was up for day parole. I wrote a victim impact statement and I sent it in. She did not get day parole that day. At some point during this time, the Restorative Justice Department contacted me and asked if I would like to attend the parole meeting. I said no. I was not physically or emotionally able to do that. So I was asked if I wanted to contact her in some way. I was given options, by letter or by video, if she agreed. I thought for a long time, and finally I had to go with my gut, that I wasn't ready to attend these things. I had met her twice in court, plus when our cars were smashed together, but I had no memory of that one. The second time was in the courthouse steps, where I was totally unprepared to meet her face to face, and I still wasn't over that yet. So I said, no, I wasn't ready to go to the parole meetings. But I did decide to send her a letter with some questions like, what was she doing in terms of rehabilitating? Could she tell me why she decided to drink that Sunday afternoon when she knew she had to pick up her 2-year-old son from her ex-husband? These were important questions for me. I felt I might learn more about who she was and why she did it 4 times in such a young life. I was hoping to hear that she was in therapy and that it was working and that she would never drink again, that she would continue to be in recovery for a long time to make sure no one had to be afraid of her driving a car drunk again. But it wasn't quite like that. Her answers were one sentence with a few, I don't know why. I continued to keep in touch through the system they have set up. The restorative justice people sent one of their staff to Nelson from the coast to see me. That meant a lot to me. We talked about forgiveness and what she knew of my offender. This agency worker, she had compassion for me, and she had it for the offender also. That really hit home for me. It was important to see both sides. I continued to receive letters with updates, and 1 year into my offender's sentence, she was allowed on full halfway house in Calgary. This was upsetting to me because I didn't know about it until it was already done. Somehow that was a mishap. I don't know how that happened, but I didn't know till it was already done. Maya, my daughter, as I said before, was in university in Calgary. And although it is a big city, fear took over my whole being. What if Maya was walking down the street and they met? Maya knew her face from the crash. Maya remembers it all. Maya remembers the driver yelling. I wasn't driving. I didn't hear any of this. I don't even know why I can't, it's just what takes over when someone has so much trauma. I have no memory of this, but Maya remembers her saying, I wasn't driving. Don't tell the cops. Don't let them find out I was driving. Maya didn't want to be reminded of that, so she opted out of receiving any info on the case. And then 1.5 years after the sentencing and 3 years after the crash, I received a call from Correctional Services saying our offender was being released the very next morning at 10 a.m. The date of the call was June 8th, 2016. The 3rd year anniversary of the crash was June 9th, 2016, the very next day. And that would be the day that she was released. I dropped the phone in mid-call. We already struggled with that day each year since 2013, trying to figure out how to spend that day. Should it be in joy that we survived a 4,000-ton vehicle hitting our Toyota Corolla head on? Or should we grieve? Each year seems to be different for us. That day was grief, disappointment, and confusion, the day I got that call. I asked myself, how could Correctional Services and the Parole Board not have the date in front of them when making decisions that would affect an entire family? They must have that data. But they didn't use it that day. And when I received the formal letter with her parole conditions, she had 5 that she had to adhere to. Alcohol and finances were basically the gist of the conditions, but not therapy, not AA, no actual treatment. Now that was a concern. She had a disease, or she has a disease, even to today. She is an addict. She is an alcoholic. She needs lifelong help. I don't say that, folks, without knowing that she said it herself in court that day. That is why I feel like I can say that she is an alcoholic. But this was not part of her release. I suddenly did not feel safe. My anxiety began to rise that day. That and the big fact that she was released on the anniversary, it cemented my need to advocate for victims' rights and to share my story, my family's story, with anyone who will listen. My daughter and I were re-victimized by the legal system and the insurance system, and this was all happening at the same time. But that part is a different story for what we're here for today. But the parole requirements and the anniversary date mishap, they were the bricks that topped off the edge, and our world was crumbling away under it all. I'm here today to share this story because I know now that the system is listening and they want to make changes to serve those affected by violent crimes. That is why we are all here today. As Eddy was saying, I am a member of the Victims Advisory Committee for the Regional Pacific area. Well, why did I join VAC? Well, I joined because they have a collective voice, as does MAD Canada, which I am also an active member and volunteer of. VAC members understand each other. We're able to share our stories. We can describe our experiences to each other and discuss how to make the system work better for those of us and our family members to navigate the system better. We don't want to be pitied or re-victimized. We want justice, and we want those that need help for their diseases and crimes to get help. At least that's what I want. I want them to be rehabilitated. But at the same time, because two things can happen at the same time, I want to make sure that the victims of crime are heard and seen. It is about justice. One more thing I want to throw out there. To feel safe that the law must make changes. That is another aspect of why I keep advocating for victims. I want to see every car installed with a breathalyzer interlock device, with all new vehicles automatically built with one. And why can't this be done? I don't understand that one. This is about saving lives. This is just another tool that we can add to the kit, but I do not see it happening yet. So I've added that to my list of safety issues to stop this crime before it happens. As part of my recovery, I wrote a book on my experience. I just thought it was going to be, something that would help me as a part of my therapy. It turned out to be a lot more than that. I think those of us who write about our trauma, we're somehow looking for a way to heal and deal with the injustices that we have experienced. As a theater artist, I recognized that I could use my work as a writer and a performer, hoping it would be one way for me to express my grief and hopefully further my recovery. It also allows me to advocate for victims because I get to be here today and tell you my story. And I feel pretty good about telling you all where I'm at because I spent a lot of time thinking, reflecting, and writing it down. In February of 2021, my book, Beyond the Legal Limit, was published. It's also been adapted for the stage. And I'm hoping that by putting it out there in such a public fashion, that we can stop this senseless crime and save lives. Yesterday, and I get notes from people who have read the book quite a bit. Yesterday, I received this note, and it just kind of sums up something that the public doesn't know very much about what happens during these types of life-changing events. So if I can just read just a little bit of what I got yesterday by Facebook, actually. Hi, Pat. I have just finished reading your book. It was certainly an eye-opener as to what people go through after the accident. I like to call it the crash, and I'll thank the people at MAD for really turning my mind into, it's a crash. It wasn't an accident. Sorry. What people go through after the accident, not only with the legal aspects, which is awful, but the recovery process and complications that can occur. I have to be honest that up until now, I was ignorant as to the aftermath. I kind of assumed that you had had an accident, you were in the hospital, you get released, therapy follows, and then you're all better. Wrong, so wrong. You and your daughter showed us so much determination and bravery throughout the years following the accident. I also didn't realize that MAD actually, what MAD actually did to help. Not only being supportive, but advice and knowledge. Your book drew me in right into your situation, and I wanted to keep on reading. Wishing you and your daughter all the best from now on. Annette. Thank you all for listening to me today. That's it for me. Thank you.
Thank you so much for sharing your story, Pat. I actually do have your novel with me, and I did read it. And I can say with certainty, it's such an incredible story of trauma and healing and recovery. And I just wanted to point out one thing that really stood out to me, and it was actually on page 136 of, it's not really chapters in this book, but the title of that chapter is called Sentenced. And you had asked the question, would she, the offender, be completely rehabilitated in such a short time? And I think that that question captured so much of the uncertainty that victims of violent crime may be feeling with respect to their safety and their own recovery. So just thank you so much again for sharing that and for putting your experience into this book here as well. Really appreciate that. That brings us to our next guest speaker, Ms. Donna Eaton. Donna, whenever you're ready to unmute yourself and share your video as well, we'd love to hear from you.
Thank you, Swayam, and thank you, everyone. I first would like to introduce you all to my daughter. This is Brooke, my rock, my inspiration, and for a very long time, my reason for living. On September 29th of 2000, Brooke was murdered by her, by her abusive on-again, off-again ex-boyfriend, Jeremy Millett. I became the surviving family member of a victim of homicide. He took many things from me, things that could not be replaced, but he did not take my voice. So today, I'm going to attempt to be her voice. The voice for so many that have been silenced by violent acts against them, or those of us that feel lost in this system. We'll also talk about some of the challenges I've had as a family member of a homicide victim in accessing services, receiving information, and along with some suggestions for how we can improve things. I'm going to attempt to describe the indescribable. The relationship between Brooke and her killer was filled with psychological and physical abuse early on. He was a person with a long criminal background, including previous attacks on women, who is actually unlawfully at large at the time of Brooke's death. He stalked and harassed Brooke constantly, and it didn't take long for the physical abuse to start. In the spring of 2000, he beat her so badly. After being at a friend's house, she was frightened and finally felt she had to end the relationship. She came home, started to put her life back together, and was making plans for her future. We were all very excited. That is when he ramped up the stalking and harassment to a level that I'd never seen before. There were incessant phone calls to our home day and night. He waited outside Brooke's place of work to follow her. He would drive past our home, making sure that we saw him so that we knew he was still around. So Brooke got a job working in the Rocky Mountain House area, flagging on a road crew. And we were so excited she was going to be away from him. But he followed her and somehow convinced her to let him stay. The problems between them resurfaced almost immediately, and he became very unpopular with her coworkers because of his behavior towards her. Finally, Brooke had made it clear that when they returned to Calgary, the relationship was over. He made a scene, and Brooke left with him in order to try and diffuse the situation. Once back at the room where she was staying, he then stabbed my daughter 33 times, ending her life. Most of her injuries were defense wounds to her back and hands. As she attempted to hide from the blows, she curled herself into a ball. Some of the blows completely pierced her body, and many were delivered after she had already died. I always wonder, did my baby call out for me while she was dying on that motel room floor? 20 years later, I can't stop thinking about how terrified she must have been and how much pain she experienced before she died. These are thoughts that haunt my days and my nights. He was arrested nearby after calling his grandmother to confess to killing Brooke. When the RCMP arrived, he stopped talking. The RCMP tried to piece together what was going on and what had happened. And by the time they had found Brooke, she had been lying dead on that motel room floor for several hours. He used his right to call his lawyer, but instead called me at home. No one believed that he could reach me, but he did. They couldn't believe his audacity, but I knew from his 2-year reign of horror that he was still able to get to us. This terrified me, and we felt we still weren't safe. In the aftermath, my family fell to pieces, and I was incapable of supporting them. I could barely feed and dress myself, and I had a 10-year-old surviving daughter. It was left to me to deliver the news that her sister was dead. I can still hear her screams when she found out. She suffered from a lot of separation anxiety after she found out about Brooke's death, and she required constant attention. I did my best to support her, which left other family members to the wayside. I couldn't cope with the fast-paced environment of my work, and I was unable to return to it for quite some time. When I did return, I couldn't do it any longer. I had to find a different line of work, which resulted in a salary reduction of about $30,000 a year. This made life even more stressful. In all of this, my 10-year relationship ended. He couldn't cope with the stress, or what we referred to as our new normal. Fortunately, I was grateful for the help and support I received from the Rockian District Victim Services Unit. They were outstanding. And when they could not attend to us, the Calgary Police Victim Assistant Unit stepped in. They were there to listen, help us prepare for the next steps, be a liaison between investigators and prosecutors, explain the terminology and processes that we could not understand and weren't familiar with at all, and accompany us to court. Both units were lifesavers in the early stages of our tragedy. These short-term victim services are critical, and I would love to see them expand and grow so they can support as many victims as possible, especially those in smaller community and rural areas. He eventually pled guilty to second-degree murder and was sentenced to life with no chance of parole for 10 years. With time already served, this meant 7 short years before he could apply for release, and 7 short years before we had to relive Brooke's murder all over again. With conviction and sentencing behind us, we felt we could move forward, but it was still really hard. Some families, however, have it even harder, especially if a murder case is unsolved, or the offender is acquitted, or found not criminally responsible. These families may receive information and services in the short term, but not much for the longer term. And my heart is with all of you. Although we received support throughout this entire process, we still felt helpless and confused. I was suffering from post-traumatic stress disorder, which caused a significant loss of mental capacity. My memory, my ability to read and comprehend what I was reading, and manage stressful situations was so difficult. I found that seeking help and trying to navigate the layers of the judicial, incarceration, and victim services system could be very frustrating and even at times futile. Accessing effective mental health treatment has also been challenging for me. Although I was offered services, they were not always satisfactory. For example, most grief programs I contacted seemed uneasy or ill-equipped to deal with a family member of a homicide victim. In group sessions, when I mentioned it, the room would go silent. Or I would hear, "We don't know how to cover that here." I eventually did find a homicide-specific grief group through a newspaper article. While the organizers were well-intentioned, they lacked a clear understanding of what we needed and how long we needed support for. They did not quite understand that we go through the grief and trauma process all over again each time the offender applies for day passes, day parole, full parole, travel passes. It starts all over again. I heard one comment from one of the organizers. We never expected them to keep coming back for so long, but that's what it is for the surviving family member of a homicide victim. Accessing and receiving information about the offender has even been more difficult. Although Corrections Canada staff have tried to be helpful, they would often use terminology that's difficult to comprehend for a layperson. And the whole process of filling out forms and talking to different people seems so convoluted. We failed to get all of the details we needed in order to access these services and information that we wanted. We spoke to so many people. I could speak to like 3 or 4 different people with different agencies in one day trying to find what I needed, that we couldn't remember who said what or where they were from, leaving me even more confused. This would be hard for people just in normal situations, let alone those of us suffering through grief and trauma from violent crime. For us, it's many, many times more difficult. And for new immigrants with English as a second language and a complete unknown criminal system to them, this is a process that does not work. We found that registering to receive information complicated, and we feel, and many victims I've spoken with, registration should be automatic, especially in instances of major and violent crimes. You're at the lowest moment in your life. I was informed that because the offender contacted me from custody, I could be on an advisory list to be notified if he ever escaped or failed to check in while on an absence. I think receiving that type of information should also be automatic. When legislation changes, we're not receiving the communication of how it affects us and the offender. It doesn't come in a timely manner. For example, victims' families can now receive an offender's progress report from Corrections Canada. These reports describe programs the offender has taken, as well as infractions and any disciplinary actions. I found out about it on the news. Not once was I advised that this was available to me. It's just really disheartening. I called Corrections Canada for the information because we had a parole hearing come up, and I wanted to be as informed and as relevant as possible when I delivered my statement at the hearing. I got into an argument with the Corrections Canada staffer. They told me I wasn't due for it, that I couldn't get it, it took too long to move me up the queue. At that point, I didn't care. I needed the information. I had a statement to deliver. I had to be Brooke's voice, and I wanted the information that I had a right to have. It's critical for victims to have as much information as possible when they go into hearings or receiving information. It's easier for them to process it and digest exactly what's going on and how you can move through it. I received that report 8 years ago. I have never received another one. Another issue is timing of notifications that Pat mentioned. They come near Brooke's death day. And as Pat mentioned, every year is different. Some years we cope, we celebrate Brooke. Other years, I can't get out of bed. Just as we're getting to a place of coping, the phone rings or the mail comes with a notification slingshotting us back into anxiety. Both agencies, the Parole Board and Corrections Canada, need to be more mindful of when they send the information to the victims' families and how it's delivered to them. We've had difficulty participating in parole hearings and decisions relating to his early release. It's been hard in the past with timings and travel arrangements, but during COVID, it was even worse, with some victims even being shut out of hearings completely and only allowed to provide written statements. Victim participation in hearings is critical, and it needs to be easier. In our case, there have been several infractions while he was on day passes and day paroles, such as lying about his whereabouts, missing check-in times, creating profiles on dating websites without disclosing any of it to his parole officer. While his passes were revoked, we had to attend at least 4 hearings in 2 years while he tried to get these passes back. When he was able to resume these unescorted temporary absences and day paroles, the subsequent reviews are only done as on paper reviews by the parole board every 90 days. This has gone on for years. How many 90 days have gone by in those years? We've had no chance for input other than writing a new statement every 90 days. There has to be a limit on how many on paper non-hearing reviews can happen before a hearing is held and everybody gets to refresh what is going on. We've been notified of travel passes he's been awarded after the fact. This apparently is due to a lag in information coming from the parole board to the CSC to us. That needs to change. He can't be out on a travel pass and me not know. I am afraid of him. In some cases, there have been no notifications of changes whatsoever. For example, he's recently been granted a 5 and 2, 5 days of absence from the halfway house and 2 days back being monitored. This happened without any notice to us, even though it was a consideration in his release plan. We weren't told. It just happened, and we had to try and cope with it the best we could. I was shocked to hear this type of release even existed, let alone know that he was getting it. This suggests that the CSE and the parole board sometimes forget about victims and we're an afterthought And it needs to be remembered, we are entitled to information under the Canadian Victim Bill of Rights. Since the 5 and 2 have been awarded, he has applied for full parole, and there was a hearing which we attended by video conference. His full parole was denied. However, his 5 and 2 continue. I'm confused. If he continues to be a risk, why does he get to spend 5 days in his own apartment in a relationship with a woman and only 2 days of monitoring? The woman that he's involved with only needs to call his parole officer to let them know when she's no longer at his apartment. I'm frightened for her, and I'm frightened for us. Another issue that affects victims is a staff turnover at CSC. You get a victims services officer that works so well with you, you develop a relationship, you feel comfortable, you feel confident that you're getting what you need, and you have a wonderful rapport with them. And then someone new comes along and you start right back from square one. They need to get up to speed on you, and you need to get up to speed on them. I know it must be a terribly stressful job, but it's so important that consistency be a part of the victim's life. We don't take well to surprises anymore. All the experiences I've described need to be addressed in some way by the Corrections and Conditional Release Act or the Victims' Bill of Rights, or both. Victims' families are often accused of seeking revenge. When we speak up for our rights and the rights of our loved ones that were taken from us, I don't feel like I'm seeking revenge. All we're asking for is a place at the table when decisions are made that affect our sense of safety and well-being. These are things we work very hard on to maintain. And at the end of the day, it's every single day. I hope that by sharing Brooke's story and the aftermath, that I've given everyone a better sense of how victims experience and navigate this complicated system, and how we're in it indefinitely. There's no early release for us. Thank you for listening.
Thank you so much for that presentation, Donna. It was very difficult to listen to, but I'm so glad that you shared it with us. I think we're going to go now to Heidi, who will touch on several of the issues that the other speakers have raised, and also talk about some of the work she's doing and how we can move forward with things. And I know we're a little tight for time. Most of the speakers have agreed to stay a little longer if we have to go over. If people need to leave, feel free. We're still recording, and we'll make the recording available to people in about a week's time. So Heidi, we turn it over to you.
Thank you so much. I'm just going to try to get my PowerPoint up here. There we go. Can you see that? Is it on the proper
Yes.
mode?
Just if you can make it bigger on your screen.
Yeah, I don't think I'm in slideshow mode here.
Joys of technology. There we go.
Yeah.
Perfect.
That's good.
Yes.
The only problem is I need my notes up here too. Why did this work before and not now? Anyways, maybe I will need Swayam to share it for me. Do you have it?
Yeah, sure. I have it here. Let me just get my screen ready.
I'm just going to stop share because I don't think I can do it and see my notes at the same time. I'm so sorry. Kwe, good afternoon, everyone. Bon après-midi. My name is Heidi Illingworth, and I use the pronouns she, her, and elle. I want to acknowledge with much respect that I am in my office today in Ottawa on the traditional unceded territory of the Algonquin and Anishinaabe people. And just as I get going here with the presentation, I want to thank Eddy, Elmer, Dennis, Herfst, and the Citizens Advisory Committee for inviting me to present to you today. And also, Tara, thank you for your presentation, and Pat and Donna as well. Thank you so much for sharing your lived experiences with all of us. You are empowering others by sharing your story. And importantly, you're also helping us, those of us in the audience who are service providers and victim advocates. You're really, showing us the way in terms of working together to try to improve how victims are treated in the federal corrections and parole system. So thank you both so much, and very, very powerful personal stories. And Donna, you did amazing. I can't believe that was your first time sharing like that today. So kudos. Thank you for telling us about Brooke and what happened to her. And just quickly, I know there was some comments and some inappropriate comments made in the chat earlier, and I just want to quickly touch on victim blaming and how it is so common. We know that victims of violence should never be blamed for the abuse, the threats, the coercion, the violence and abuse that's perpetrated against them, but it still happens all the time. And instead of saying, why does she stay with him? We need to ask why the perpetrator is using acts of violence and abuse and coercion, and hold them accountable for their actions against normally vulnerable people. Victims of crime are often vulnerable, and no one deserves the violence that they're subjected to. Just if you could go to slide 2 there, Swayam, that'd be great. Just very quickly, I'm actually going to skip over most of the part about my agency, just because we're short on time. So just the one right before this, that's slide 3, I think. But I'm here today representing Ottawa Victim Services. My role here now is Executive Director. Please check us out on Facebook, on Instagram, and on Twitter. You can give us a follow. I'm just going to go right over now to slide number 7, please, Swayam. And I'm going to move into the federal corrections and parole system. You have to load all, sorry, the PowerPoints, those all go individually there. And then you can go to the next one. And here we go. So, oh, the one before that. I want to draw everyone's attention to some really important research that I commissioned when I was ombudsperson. And it was looking at victims and survivors of impaired driving in Canada's parole system. And so you can find this paper if you want to have a look at it on the Federal Ombudsman's website. So it's victimsfirst.gc.ca, and look under publications, and there's a research corner. And this new research was put together by Mothers Against Drunk Driving. And it looked at the experiences of victims and survivors who are facing a conditional release process soon after sentencing of the offender. And they had almost 100 participants who responded to their survey questions. And there were some really key findings. from this research that I think we've heard reiterated today by both Pat and Donna, but victims engage in these processes post-trial, knowing that they're going to be very painful. And they have contradictory feelings about the offender. So they want this person out of their lives, yet there is a very strong need to participate in conditional release processes, right? And then this creates that contradiction of wanting that person out of your life, but then they're continually in your life because you're following them through as they serve their sentence. So very difficult for survivors. The timing of hearings. So a lot of times victims report, especially when it's impaired driving, that there is no real chance to breathe after the sentencing hearing. And this leads to more requests from the system, right? Like we need a victim impact statement from you. We need another statement. We need to know if you have concerns about the area to which the offender will be released, all of that. So you're continually being asked for more information to participate. And so this is really difficult because, you know, it's really emotionally painful to be involved and then constantly being asked to retell, how has this affected you? What are you fearful of? All of those concerns that victims have. And so this research found that in some cases, there is a very negative impact for victims and survivors to being involved in the parole process, but most of them are willing to pay that price and most don't regret their decisions. So even though it's almost like a burden to be involved, at the same time, they feel obligated because of, obviously, if they're speaking for a loved one, as we heard from Donna, victims know it's going to be a painful process, and many of them do not have any, you know, they haven't shared any really personal benefits of registering. A lot of times they describe more frustration and hurt. You heard both of Pat and Donna talking about re-victimization by the system. But again, many people feel obligated to register in memory of their loved one if they lost someone, and a need to speak for them or to represent them. And then, of course, if you're personally injured as well, and you have safety concerns about the person who caused the harm to you, you also want to have a voice in that process. So thank you. Can you switch to the next slide? Please check out that research. Really great stuff. Best practices in corrections and parole. Information is what victims need the most. It is the gateway right. So in my opinion, and I think we heard the speakers today sharing this as well, we must proactively inform victims and survivors so that they can know their rights and assert them throughout the process. So the Canadian Victims' Bill of Rights does not provide victims with automatic information about their case. They have to specifically request it. And again, how are people supposed to know, how are a traumatized persons supposed to know that they have any rights at all unless a criminal justice official tells them that they do? So requiring someone who is recently victimized to ask for information or to self-register, like there's so many problems with that. But first of all, people may not recognize themselves as a victim, just as, you know, someone who's been traumatized. This is difficult for many. And then there's other factors, socioeconomic factors and other barriers like language or cultural identity and background that also play a role in whether victims are going to be aware of their rights or not. So in the corrections and parole context, especially, I think that self-registration is really problematic. And we know that that's what happens right now. The law requires victims to register themselves with Correctional Service of Canada or Parole Board of Canada to receive any information about the offender who harmed them. And to me, this is backwards. It should be automatic. especially when offenders are being considered, given the implications of someone being considered for parole or temporary release. So there's some provincial victim services programs that provide or they're mandated to inform victims about their rights in this area, like Nova Scotia is an example of that, but many provinces don't have those mandates. So victims, again, are left on their own, as we've heard today, to navigate these complex systems and to try to process them and engage with them. And privacy is used as an excuse to prevent victims from accessing information. So current federal policy is that it would violate a victim's privacy to contact them about the offender who harmed them or about their rights, such as, participating in a hearing or expressing concerns related to safety. And in my view, this completely violates the spirit of the law, and it reinforces barriers to the implementation of victims' rights in Canada. The result that we can see, we have numbers to show this, that self-registration is not working, because we know the number of registered victims is very low compared with the number of incarcerated individuals. And actually, we know that offenders have multiple victims, so we should see more victims registered. And how do we fix this problem? In my view, we have to have automatic or proactive registration of victims when a federal sentence is imposed. And then what we do is you have an opt-out provision for people. So let's give victims and survivors personal agency to decide if they want to remain registered, and they can decide for themselves what is in their best interest. So this is the most trauma-informed, strengths-based, and victim-centered solution to address this significant lack of victim participation in federal corrections and parole. And it exists because of this requirement to self-register. Next slide, please. People simply don't know that they have rights when they become victims of crime. So citizens do not ever expect that they're going to be victimized. And then when they are, they have no idea that the onus is on them. So the law puts the onus on the person who is harmed to engage or to ask for information, right? To register, to understand their roles within this criminal legal system. And this is wrong. So I strongly believe criminal justice officials have to be accountable for providing and informing victims of their rights immediately at the outset. Otherwise, victims, survivors, family members cannot engage and assert their rights as they move through the criminal justice system. So we really, in my view, made these recommendations when I was ombudsperson. We need a national education, public education campaign. We need to target citizens in general to inform them about their rights as victims of crime, because you guys, every year in Canada, more than 2 million Canadians report crime and violence to the police. And we know that only a fraction of crime is actually reported, but it's especially important to inform people they have the right to information, because this right opens the gateway to services and other rights. So this sort of a campaign would really empower victims and enhance their confidence in the criminal justice system. I also believe that a national effort to train criminal justice personnel on victims' rights is needed, and that this would create better a system of national standards for the treatment of victims. So all criminal justice personnel understand that they will be held accountable for ensuring that victims are given the rights that are stated in law. And we need to evaluate this training on an ongoing basis to make sure that it's effective. You can go to the next slide, please. Again, just to reiterate about meeting the needs of victims, right now, it's really important in my view that we continue the practice of virtual parole hearings, and I recommended this as ombudsperson. Victims seem to prefer participating virtually from the safety and security of their homes. It's easier and more convenient in many cases than traveling long distance to physically be present at a prison. And the Parole Board's own data right now is showing that participation is way up over the course of the pandemic. So while some people do, many victims may not want to attend prison in person. Sometimes there are significant fear and safety concerns, and then there's just logistical difficulties, right, around travel and reorganizing your schedule, taking time off work, all of that. So allowing for remote participation is really critical in my view. To make the system more accessible, and beyond the pandemic, it has to continue. Victims want choices. So let them decide whether they want to attend in person or participate remotely. Again, empowering victims and survivors with choices about how they can participate is a trauma-informed approach. Next slide, please. I made 15 recommendations when I was ombudsperson to strengthen the Canadian Victims' Bill of Rights. And I'm just going to quickly go through 4 of them that pertain to corrections and parole right now. But again, most importantly, automatic provision of information. We need to amend sections 6, 7, and 8 of the CVBR and provide a proactive approach to upholding the legal rights of victims. So change that wording to every victim shall automatically be provided with information about their case, and so on and so forth. We need to assign clear responsibilities to officials. So right now, the Act says that appropriate officials in the criminal justice system have responsibilities towards victims. I think we need to list who those officials are who have direct responsibilities to victims of crime, and those are police officers, those are Crown prosecutors, judges, Review Board members, Correctional Service of Canada employees, and Parole Board of Canada employees. Thirdly, I think that we need nationally consistent data collection on the treatment of victims in the criminal justice system, and it needs to be reported publicly. And all of this data should align with the rights that are enumerated in the Canadian Victims' Bill of Rights so that we can track and measure how rights are being upheld across all jurisdictions. And lastly, in terms of the federal corrections and parole system, right now, there is nothing, no assistance provided to victims in terms of collecting restitution. We know that restitution orders are part of the sentence, but this is overlooked and victims are left on their own to try to collect it. And so if not paid, I strongly believe that we have to change the legislation to require that victims are provided assistance with the collection of a judgment that is enforceable against the offender. So this would recognize the responsibility of all governments to assist with the enforcement of court-ordered restitution and court-ordered obligations, because victims do have rights to receive reparations for the losses they have suffered. And then the last section that I'm going to touch on quickly, last slide, please, or last 2 slides, I guess. Thanks. Thank you for switching those. I just wanted to tell you about some of the things that I've heard from in terms of systemic barriers and what we've heard from Indigenous stakeholders and clients over the years. So we know that who gets access to information is impacted by trauma. And then there's also significant barriers for BIPOC people. So persons of color, Black, Indigenous, persons of color. Survivors and people who are harmed may have a reluctance to ask for information because of the trauma that they have experienced, but it can also be, like I said earlier, because of language barriers or other issues causing people to distrust authority figures like police, for example. So this is particularly true when we're talking about members of diverse, minority, racialized, and Indigenous communities where they have faced systemic and other forms of discrimination historically. So also, we know that the system, all the way from policing through the courts, through corrections and parole, we are lacking disaggregated data about how BIPOC people are targeted and targeted groups are treated and how their rights are upheld. The final report of the National Inquiry into Missing and Murdered Indigenous Women and Girls noted that Indigenous women, girls, and 2S LGBTQIA persons are over-policed and over-incarcerated as potential offenders, yet underprotected as victims of crime. So we need significant investments in improving how we record disaggregated data by all criminal justice institutions, because Canadians deserve transparency about how our criminal justice system is working and if it is treating victims fairly and respecting their legislated rights. We know that also we've heard from Indigenous survivors, affected family members, that they want to see Indigenous programs and processes reserved for First Nations, Inuit, and Métis people. So I have had clients and stakeholders tell me over the years that they're concerned that Indigenous correctional programs and processes are being accessed by non-Indigenous offenders. So this, for example, could be healing lodges or at the parole stage, elder-assisted parole hearings. And then last slide, please, Swayam. We know that right now there is a lack of policy at the federal level when victims raise concerns on the grounds of Indigenous cultural identity or heritage. So to give you an example, some victims have gone to or shown up for a parole hearing and been surprised to learn that it's going to be an elder assisted hearing when the offender is non-Indigenous. So Indigenous family members have told me that they feel that their culture should not be appropriated or co-opted by non-Indigenous offenders. And this amounts to additional experiences of systemic violence for them and cultural genocide, similar to what was inflicted by residential schools, the 60s scoop, and the ongoing missing and murdered Indigenous women and girls crisis. In my work as ombudsperson, I heard that elder-assisted hearings should be reserved for Indigenous peoples first and foremost. We know right now that all offenders can access or can have access to an elder-assisted hearing. Another concern that has been raised to me is that registered victims who identify as Indigenous should be provided with culturally appropriate supports, such as an elder, so that victims feel safe and culturally supported to participate in corrections and parole processes. And again, this is part of the Missing and Murdered Indigenous Women and Girls calls for justice. Family members and loved ones of victims must have their cultural, emotional, and spiritual needs respected and have continual access to ongoing programs, resources, and supports that are culturally competent and trauma-informed. And so we need to keep moving towards this, doing better in this regard when it comes to federal corrections and parole. And so I just want to, I'm going to end there. This brings me to the end of my presentation. Thank you again for letting me share some of my professional experience. And I'm happy to answer any questions. Thank you. Merci. Miigwech. Merci. Nakurmik.
Thank you so much for that, Heidi. While Swayam tries to get back to her screen, we have some questions in the Q&A window. Some of our panelists need to leave at about 2:15. Pat in particular. So if anybody has any questions for Pat in particular, if you could type them into the Q&A window right now, that would be really helpful. We'll try to get to all the questions. So we'll have to go over a bit. If it goes on for too long, I think what we might do is ask some of the panelists to provide written responses maybe to some of the questions, and then we can forward those to people along with the video of the webinar. So let me just go to the Q&A. Tara, just going to see if there's any new questions for Pat in particular. Don't see anything yet. Several of the questions look like they're for Tara, and I'm going to start with the really easy one. If a victim's language preference is other than English or French, how do CSC victim officers communicate to the victim? And does CSC provide interpretation to victims through a third party, or are victims expected to bring their own interpreters?
So we have a couple of different initiatives that we've been working on throughout. We don't have access to translators in victim services directly, but what we've been trying to do is reach out locally to the agencies that are providing those services and languages. We've also, our general information about corrections, we've had translated into the most, languages that are most present in many of the areas across Canada. So I can provide the like our guide, our overview of federal corrections and criminal justice and the information guide to victims. I can share that with, oh, I'm not on video, my apologies. I can share that in the chat line. And then we try and connect locally with different victim serving agencies that may have that type of service. Also, we have the ability to work with the victim where we can, how they got to us, and work through with family or representatives or people that try to continue to do that work in that way. So there's still gaps there, definitely, but we're trying to create those types of connections where possible. And probably one of the things we've done internally is in the staffing, because we know that we've heard from our Indigenous advisory committees and the Indigenous victims that we work with, that it is important for them to have connection, and others, minority groups that we work with or marginalized people, that connection to people. So in our staffing, what we're trying to do is engage to bring people on board with Indigenous heritage and or cultural competencies and knowledge, so that as we move forward into the future, that we try and represent in our victim services unit a more comprehensive group that's providing service. And where we don't have that, work with people in community and victim agencies that do. So to maintain our cultural competency and awareness that there are very unique challenges for people, whether it's in their common trauma responses that they may have as victims of serious crime, or the other unique components that they have that they're consistently challenged with around systemic barriers and things of that nature. So that I'll post that website for you for at least the written components of it. Maybe that can be shared out. That's the first question, I think.
Okay.
Thank you, Tara. Should we ask that question by Sarah Henschel, was it?
Yes, so yeah. If someone is up for parole, is there any way to send in a statement to influence the parole decision? And if so, who would the contact for that be?
Oh yes, that's one of our main attempts to try and ensure that, similar to like a victim impact statement at sentencing, now we have victim statements, both for Correctional Service Canada decision makers, but also the parole board. So they can work with they don't have to be registered to receive information either in terms for victim services with CSC. They can simply provide that information. If they want to actually participate and read it out at a hearing, they'll need to work with their parole board counterpart. So we have, you can send that information via email, via the portal. If they're logged in that way, they can upload and get the information. The Parole Board of Canada has recently published a victim statement checklist that kind of provides some of those sage tips and tricks to writing them. MAD Canada has a very good video that's come from some victims directly who have participated in that and are providing a peer review and experience around what does that mean? Because we hear from victims all the time that this is a very intense time. We hear consistently, depending on how the law works, that the eligibility dates and the decisions, like scheduled reviews, will land on the anniversary date of the death of their loved ones. And so already that has a very powerful impact on what's happening for them, and then to try and submit their statements in there. So how to do that. That's one of the reasons corrections has started. It sometimes looks as duplication, but we're trying to work with parole officers and those that are registered with us to prompt that earlier, to get them their correctional plan summaries, and then they write their statements earlier, and then they can focus on closer to the date what they're going to say and the statements that they're going to submit to the parole board. In any event, contacting a victim service officer or a general line or emailing us, we will provide the information necessary to try and participate. The cautionary note, one is a question about privacy. So offenders, their information is private. We don't release it unless the law allows it. And the Corrections and Conditional Release Act allows for victims to access information about offenders because of they've suffered harm as a result of the offender's offense or action. So the law allows victims to get information that the general public wouldn't get about the offender who harmed them. And that's the work that we do to ensure that they get that information. That's not private to the offender in that sense. The law actually facilitates it. So on the reverse, offender, when a decision's being made by a body, whether it's corrections or a correctional decision maker or a parole board decision maker, there are some natural justice laws or duty to act fairly requirements that say that anyone that is having a decision made about them, they need to have a context of what information the decision maker is going to have. So when a victim decides to submit a statement, or any public community member can submit a statement as well in a different format or, you know, through different means, but ultimately submitting information for the decision makers to review, that information does have to be shared with the offender before the decision is made. They get all access to information. Now, there are some nuances to that around how to share. So that's some of the checklists and the work that we do with victim service officers and regional communications officers to sensitize victims to that, the types, how that would look, how it'll be presented, if they want to think about what they're going to submit, because they have genuine and real fear sometimes that if they share, then that will result in protections issues for them. On the other hand, if they don't share, then decision makers won't understand what's happening for them. So to make an informed decision about what to submit, there's a lot of information that is available to help victims make that decision in a good way. And so we can support some of that and direct to other places to do it, but definitely they can submit it. We even encourage that you can submit related from the onset. Do you want no contact orders? Do you want a geographic restriction? Those things you don't have to wait for a hearing. You can submit that from the get-go if that's something. It can change too. So you can update it. That's one of the things the Corrections and Conditional Release Act actually provides for, is we need to have updated victim information. So in cases where somebody's serving a life sentence and victims have submitted a victim impact statement at court at the time of sentencing, well, a life sentence is a life sentence. And so as you go through the many years, they can still update their information. We have everything that, like if they've consented victims, we have it, it's on file, but then they can update it. And it's changing, it's dynamic, right? As they start to decide how they want to engage and participate. So yes, definitely we would do that. Long story, but it's an important one. That is the right to participate in these decisions. It doesn't mean a veto. It doesn't mean you get what you ask for, but definitely in the decisions, there's a requirement with the decision registry to see why a parole board member made the special condition. And for UTAs, if a CSC decision maker makes it, we will share that with victims about why or why not, why it wasn't imposed for a geographic condition. So there's some nuances to that will help victims understand it. Doesn't mean agree, but understand what it is and how to access those and participate meaningfully. So that's all.
Thank you for that very thoughtful response, Tara. I'm going to be directing another question to you, and perhaps maybe Heidi and our other guest speakers could chime in. Feel free to. But this one is, I'll just read off the question here.
Bye, sorry.
Bye, Pat. Thank you for
I have to
Take
go.
care. Thank you.
Okay.
Thank you, Pat.
My pleasure.
Yeah, so the feedback provided during this webinar has included victims having a lack of information provided in a proactive and clear manner. Why is it that victims are registered in a proactive manner within the provincial correctional system, but not in the federal correctional system?
The legislation that governs our work indicates it has to be upon request. So the law has guided both Correctional Service Canada and the Parole Board, because we share the same legislation. We're part one, they're part two, that says at the request of a victim. Now, I can't speak to the provincial and territorial services. There's legislation that guides them, and it can be very different from one province or territory to the next. And so
yeah. And I was going to say, Ontario, you have to register provincially as well. So it's kind of the challenge of privacy being used to, like I said, prevent, I mean, there were good intentions with it because they didn't want to re-victimize people by contacting someone who doesn't want to be contacted. But to me, the approach should be, let's give the survivor personal agency to decide. So you reach out, you say, this is what is available to you, this is the information, and then they can say, I'm not interested, I don't want to have notifications, I'm gonna say no thank you, and let them make that decision, because we know it's really damaging when people don't have the information and they miss opportunities to be involved, and they miss chances to speak to their safety, and you can't go back in time, right, to have a parole hearing again there when decisions are made. So to me, really important to give people the opportunity to decide for themselves when there is, especially a federal sentence, when we're talking 2+ years. In the system, when there is really robust opportunities for them to be heard and participate.
Did anybody else want to chime in? Okay. We received a question in advance. This is probably not an easy question, or maybe it's more like a comment, I don't know, but I'll read it. A criminal offense doesn't have just one victim. In addition to affecting the primary victim and their families, a crime can affect entire communities, especially if they are small. Although we have services for individual victims and their families, what do we have for communities who are suffering from the aftermath of a terrible crime?
Well, we have, and Tara can probably speak to this a bit more too, but the Canadian Victims' Bill of Rights did bring in the community impact statements into the criminal code. So communities now can submit how, to the board for consideration, how they've been impacted by the crime. And actually, I know some communities as well are working on it at the trial level too, hearing from, I know we did a panel last year or earlier this year up in Whitehorse, and in the court system up there, the judges are really interested in hearing the impact on community for certain offenses. So trying to give, members of the community, the collective, more of a chance to express how they've been impacted. That is one, I would say, of the positive things that came in with the Bill of Rights. Tara, did you want to add anything to that?
Definitely. We have, judges can impose a section, there's a certain section in the criminal code that will allow to hear from community members and submit those statements, as well as at CSE and PDC. Again, if victims are submitting statements, there's also a capacity for any community member to submit information for review. And that would be addressed as well. Yep.
Great. Thank you for that, Heidi and Tara. I think this question will be kind of directed towards Tara again, but feel free for everyone to chime in. Sorry. We're just a little bit curious about the work you do with federal, provincial, and municipal and non-governmental partners in your role as a liaison. How do these relationships inform Correctional Service of Canada policies and the treatment of victims? What successes have you seen, and what lessons learned have you encountered during your tenure?
That's a really good question. And from the onset, when I said when we started about trying to engage to learn ourselves what was already in the victim community, and then raise awareness about what we're doing and meeting somewhere in the middle. When we're working with people all across the country in rural and urban settings, it's an individual circumstance for them. And so we hear stories and it's very really important when we're working with people that we put into context where they're coming from. And then from there, try and work with them around, have you had services in the past? Have you tried different things? Sometimes there's systemic barriers to them accessing it, or they've tried a service and they don't feel that the service met their needs. And so we're constantly looking at and using our network. As victim services staff, we have a third of our job is to make sure that we're trying to engage through outreach presentations to raise awareness, but also learn about what's there. And then when we're working with individual people, we're trying to hear and identify what are your needs, what do you have access to, and through our networks, can we find a local resource or maybe a national resource that'll provide some type of emotional or psychological support with this financial access that they have, or through the criteria, and connect people so that they can meet individual people's needs. That's the work we're trying to do. We don't cover all the needs that victims have. And so if we're trying to understand what those needs are and what's available, and that really is at the heart of, there are, when you look at these directories and when we talk to people, it's like, oh, there's all these services, but individual people who one day, like, there's no planning to be in this circumstance. And so when it starts, you're dependent on who, when it starts with police, who you've made contact through the legal system or your community of interest to try and figure out what is available. You might do a little bit of networking. We try and do that too. We have outreach objectives for ourselves that we each year to year are working on. In COVID, it's been a bit more difficult, but we're doing telephone and virtual. So even these types of events where it's a part of what we do. And we'll continue to be so, because it's not automatic. And there are, as much as there can be generalities, every case is its own, and every person's circumstance in it and their access to services is different. And so how we try and connect cold calls sometimes, right? To say, hey, what do you provide? And then we build a relationship from there. So.
Quick question about training. The chair of the Kamloops CAC would like to know, are staff required to take cultural safety, sensitivity, and humility training?
So in corrections, we have a number of mandate-wide mandatory training for cultural competency and diversity training, as well as understanding different communities. So Indigenous challenges and concerns, and what's that impact on our role in work, both on the offender side and the victim side and Canadian side. I mean, how does that look? How do we understand from this perspective? So we're constantly bringing in people from community to share with us and broaden our understanding and competencies in those areas, and to maintain it over time. So that's the first piece. So we have those definitely that we're ongoing trying to continue with. And then we have internally within victim services, we have a key component of our national mandatory training for victim services around those pieces, because of course the unique challenges for victims who are in those minority groups are language barriers and systemic barriers. How do we break those down for ourselves if we can, or listen when we're not? And what does that mean in being trauma informed for people who have it's about needs analysis. Where are you at and what can we do with you? That's if we're talking with you. And then of course, how do we create opportunities to meet with people in their communities and do outreach and work with them in here and take their feedback and improve our service.
Okay. While I look for one of our more difficult questions, another easy one. Does the person who wants to read their victim impact statement need to be registered? And this person says, I'm the one who's registered, but my parents may want to read their victim impact statement during the parole hearing. So I imagine they're not registered. So
I that's a very detailed conversation with a parole board staff member, but my understanding is that they would need to work through that in terms of to be registered or not. But to read it, I believe that they would need to be. But again, I would really encourage you to go and talk with a regional communications officer, because there might be nuances to that would inform how to go about doing that, either from the victim being registered or reading or not. Yeah.
For Heidi, can the role, work, and authority of the ombudsman, I think it should be ombudsperson, for victims of crime be expanded or strengthened in any way?
Yeah, I think it can. I would like to see the office be more independent. I think it should report to Parliament and not the Minister of Justice. I think that it should be the office that receives the complaints related to the Canadian Victims' Bill of Rights. And you know, to sort of make the complaint system a little bit more simple for victims and survivors, because right now there's a double step process. You have to complain to the agency first, and then if you're not satisfied with the response you get, you can seek a review from the Ombuds office. So yeah, I would like, I think that there's ways to strengthen the ombudsperson's role. You know, the way that the offices were created, they don't report to Parliament like the correctional investigators. So I would like to see the ombudsperson for victims of crime have similar, I guess, strength of voice in terms of independence and report to Parliament. Versus the being so attached to a certain department.
Gwen had a follow-up to her question for Tara. Do you have Indigenous cultural safety training?
I'm sorry, I don't know the distinction for that. So I would, in terms of that specific title, not to my knowledge. In victim services.
Thank you.
Doubt. I'll ask.
For Donna, and I think this is quite big, but can you speak to the need for early intervention for offenders with violent and often protracted criminal histories? Actually, that's for anybody.
Sorry, can you repeat that, Eddie?
Can you speak about the need for early intervention for offenders with violent and chronic criminal histories?
Well, the way we looked at it and the way we still see it in Brooke's case is the catch and release system that is our criminal justice system is partly responsible for him being at large at the time of her death and having the ability to travel up to stalk her. He should have been in jail. His criminal record is lengthy and complicated. And as I said, previous infractions against women makes it really, really difficult to understand how he was free to chase her up to Rocky Mountain House.
Did anyone else have any to add to that?
I just, you know, what Donna describes is unfortunately too common, and it seems like a lot of times these guys with serious histories are slipping through the cracks, and vulnerable victims suffer and are killed, and it's just it just speaks, I think, to the need for as the question proposes, more early intervention and you know, support to ensure that in treatment and getting folks who are dangerous, potentially dangerous, into the care or into the place that can give them appropriate help sooner. We can actually prevent violence before it happens if we intervene early enough. We know this, there's evidence, lots of evidence from around the world. There's lots of programs that work to interrupt and prevent violence. So we need to invest much more heavily in this in Canada, all over the place, because we can, you know, what happened to Brooke, someone could have intervened. It was preventable. So all of these homicides, intimate partner homicides, are preventable. There's clear warning signs leading up to it, and we need to do so much more to prevent sexual violence, homicides, child abuse in Canada. We can prevent it.
Thank you, Donna and Heidi, for that. I am familiar with the Alberta government sort of considering a provincial police service where they would have more community police, closer integration with social services, and this has also allowed, or at least they've been able to think of having more involvement by Indigenous people in their governance. And I bring this up because often when a individual has been victimized, more likely than not, the first point of contact with the justice system is with police agencies. Do you think this should be something the BC province might want to consider in strengthening services to victims of crime, and particularly our Indigenous populations as well?
Who's that for?
I'll throw it out to you all.
That's a tough one. I don't know that more police is the answer anywhere in Canada right now. I would like to see more funding for community-based support programs and services to respond to a lot of the things that police are getting called for are not criminal matters necessarily. You know, mental health issues, addictions issues. We need to put, again, and this ties back to prevention and how are we intervening early enough with people to prevent violence. But I think that we have to be careful in this financial climate around where are we making investments. And to me, we don't need more money spent on police, courts, and corrections in this country. We spend billions of dollars every year, over 22 billion, probably higher than that a year, on those three systems in this country. And we need to put more money at the front end into prevention and stop violence before it happens. And then we're going to actually save a ton of money at the back end on these systems that don't need to be so big and robust, in my opinion.
Do we have any other opinions?
I think I'll chirp in here. I think working in corrections at the back end, where we talked about that 2.2 million crimes a year roughly are reported. If you look at the Corrections and Conditional Release Act reports, we have them too. We track stuff. About 5,000 of those a year result in a federal offense. And in a way, that's a good thing, because 2 years to life means that somebody has been harmed seriously. They've lost a loved one or have been physically harmed in the most serious and tragic of ways that many find in the larger community as entertainment. But for people who have gone through this experience, it's a tragic and surreal and continues to be ongoing throughout their lifetime and the lifetime of the offender. These are their loved ones, and this has happened to me. So when we start talking about it's a good thing that it's 5,000 a year, but on the other hand, then that has implications for people who are the victims of, like, it's rare, but when it happens, the significance of it is huge. And those connection, peer support is so critical in the literature around support for victims, or for anyone as human beings, as we start to address what's happening for us. But that lack of connection across Canada for victims of homicide, for victims of serious crime. So that's the importance of those agencies that bring those communities together. I'm thankful that we have virtual hearings, right? I'm thankful that we have these COVID has helped us in that respect, because we can connect like we never have been before. And we're more comfortable to do that connection. And it's important because those pieces, but when we talk about the back end of, it's good that there isn't that many, but when it happens, it's very serious. And so we need to take efforts and the work of corrections and parole board in doing those pieces in a good way, that there are treatment and programs and monitoring and diligence around trying to understand criminal deviancy and that management with our legal systems and the law to acknowledge rehabilitation and move back out into community and manage that. Not in a no-risk environment, but in an undue harm environment. There's some legal criteria and the efforts that our colleagues in operations go through. On the other hand, for victims of crime who are going through this and their lack of connection and the supports that they have, we know that they need more support to move through some of those pieces and understand it more meaningfully. And so, you know, it's complicated. And yes, we want to spend money at the front end to avoid it, but there are some very real needs at the back end where this has happened and we're engaging in it. So how we get that right, I think, is a fulsome conversation to have amongst and in concert with each other, from police to courts to corrections staff, right? And victim services and victims and offenders and community members, that it isn't kind of through the lens of one, and some understanding of those challenges that are marginalized people or systemic issues. It's complicated, and we do our best, but there is a focus to be had, right, of where we're going to spend that. So definitely for victims, there are some needs there that are unattended in the formal legal system and in the and so that I think we're all here saying, hey, let's make sure that we're aware of it and that we take it into consideration when we're making those types of financial decisions, and that we understand that for that small group of federal correctionals staff, offenders and victims who are working it through, it's small, but it's serious. And it has legacy forever around the lives of people who are trying to work through those very complex times. And for most people, thankfully, they don't have to experience it, but when you're there, it is vast. So I kind of muddied it a bit, but I think some of the understanding it better moves a long way to trying to say, okay, where do we go to next? And hearing where are the needs of the client in there? Where is the needs of the victims who there is a gap here and we need to attend to it? To me, that I think is the first part. Stay there.
Yeah, thank you for that. There's so many moving parts to making sure, we can strengthen our services to victims and also support their recovery in the aftermath of crime. It is now 2:40, and I think this is a good time to close our discussion for today. First and foremost, just want to say thank you so much for Donna and Pat for sharing your stories with us today, and letting us in on some of the experiences that you've had with Correctional Service Canada and navigating this complex system of supports. Thank you to Heidi and Tara for taking time out of your schedules to be with us as well. We really appreciate your insights and your experience working in the justice system. Eddy, was there anything I had?
I just wanted to mention, so there are some remaining questions, and they are a little detailed, and so we'll try to get some written answers when we send out a link to the video and also to the slides. So we wanted to get to all the questions, but we can't, and some of them are a bit detailed. So yeah, that's all I had to say on behalf of our Citizen Advisory Committee. Thank you to everybody who came. I was really pleased to see such a big turnout. It's bigger than our Older Offenders webinar, so it's great. And I think we can put up the slide once more with the resources and also the contact information for our speakers who were willing to provide.
Thank you. It was great meeting everyone. I appreciate all of your time and attention to victims. We need you a lot.
Thank you so much, Donna.
Thank you.
Thank you, Donna.
Bye, everyone.
Bye-bye. Thank you so much for coming.
Bye.
Thank you. Bye.
So thank you, everyone. And I think officially ends the session, and we can stop the recording now.
Okay.